Okay, new week begins. So we have a Monday class. Can you get up? Stand to class. I'm tired. And as usual, I prepare printout to cover this class discussion. You may rise to retrieve the printout. Yeah, I've gotten this. Okay, thank you. And this is class chart. Okay, you now see in the projection the subtitles about this class, International Commercial Dispute Resolution. So we may return to some of substantive laws we have not dealt previously. Probably this topic would often be delivered in the last class of this term. I will get it first, and later for the classes, we'll probably for the next 2 or 3 weeks, reserved with some of portion vacated or neglected, and particularly of cases pertinent to the scope of class discussion. And one reason to get this in primacy in terms of order, class order, would be the awareness about the procedural and kind of a civil dispute, actually, for the case, would facilitate to have a better picture about understanding the international trade law. So consider that point to advance to this class. Of course, this topic are dealt as accompanied by cases and box office, as you see in the printouts delivered. And cases and other highlights will be for the next class, Wednesday. Of course, in the course of this course, you will find some of actually contentious points in public policy and other embedded understanding of a private dealings in business, concept often private. However, you see in the area that some essences were reserved to interplay. For example, what is state immunity concept, and also the court position to recognize and enforce the foreign judgment, as you see. So you now will see the competing authority, as you see, between the public and private, and also national and international. Often the international community now stands on the liberalization paradigm of economy, as you see. So actually that is also commitment that WTO now operates to sustain. So what is optimum in the international economy? What is division of labor? How do we maximize the products and material welfare for the global citizen? and what rules and covenants are governing to regulate national authority in terms of a desired condition about world economy. Actually, a public governance concept would be extended and far effectively in the economic dealings by the initiative of WTO. Often we recall basically the philosophical origin from Bentham. He is actually a very influential figure to advance the theme of public policy and others. You may know the words great maximum happiness for great numbers of people. And as I once said, you see the kind of also the dilemma which might be between private and public, and kind of ambitious vision about a universal rule for public governance. His point also have some assumption impliedly about the private context of a interaction. He is actually a lawyer in Great Britain at that time, and you may see some influence from David Hume, from German philosopher, and also a kind of a concept, liaison, or the bridge network, espoused by Jean-Jacques Rousseau, also come into play to interact with private and public. So he made many reservations about private laws or civil code of European continental states. However, there still remains in structure and hypothesis about dealing with this question, international commercial dispute resolution. As you read over the course, you will see some of tendency which is very strong and embedded about commercial dealings, where the business people often prefer to rely on a alternative dispute resolution, particularly what I call a commercial arbitration. What that tendency implies? So it entails a very intriguing concept that often the business people embraces. And you may find in printout the paragraph the Japanese understanding, which prevails the commercial group in Japan. See, arbitration is actually not optional, often practically employed over the course of dealings. So it is actually seen as a strain for the business people if they prefer a litigation, a kind of a compulsory, more ordinate, and also some mechanism in operation within authority or command and dictate. Court forum would not be adequate in their perspective, how to consider, if they do not choose arbitration for the dispute settlement. And also, some commentator may say, well, the Japanese people are economic. So the worst attribution, how do you consider the economic animal? Actually, it has two sides of coins. It may defend the Japanese people. However, it also may come as a praise. It is actually pivotal. And the most dominant factors to consider the economy in this global country. And one influential entrepreneur in Japan, Sony Roland, had once said that now we are living in a borderless world. There is no country or no sovereignty. Only entity we now perceive would be enterprise forms. And forms and enterprises in contemporary global economy are never identified by some of designation about a nation or national origin or others. In the classification, would Samsung be an international corporation? How do you consider? The Korean corporation with actually multiple locations, about production facilities and sales representatives. And in the context of economic dynamism, the alternative dispute resolution, a commercial arbitration would be more subtleties and reasonable reason and persuasion to fit within its nature of commerce or economy. Of course, there are several practical reasons to prefer a alternative dispute resolution. For example, expertise of a arbitration panel, or kind of a cost factor. It would be less costly and less time consuming. And also, we may identify some formal trend if we advance to the litigation other than arbitration. In some cases, that would not be practically convincing with no concrete evidence. It's just the atmosphere and some kind of influence. How do you, of course, the national judges often committed in earnest to reach a fair conclusion of the case, as you see in what Apple versus Samsung is interesting. However, the kind of legal culture and basic disposition of judges typically illustrated common law and civil law tradition, and also morals in socialist and other indigenous group of legal culture kind. So the justice may be apprehended in some of esoteric or not a uniform fashion, as you see. So that's the point, actually difficult. For example, however, the arbitration may enable parties easy to access to the process, less costly. And also, they may effectively avoid the chances to select the forum state of one of parties. So it is actually a sketching whether and how the commercial dispute may be resolved, particularly whether it should proceed to formal process, litigation, commercial arbitration, and what we say as a more informal way about mediation or conciliation. For example, the standard form AAA now encourages to use the mediation as an alternative resolution case. And we may see the custom arbitration clauses later. What you see, it also help you to grasp the class discussion and dotted a title. Is that Hague Service Convention, you see? Subject matter jurisdiction, general personal jurisdiction, all kinds of well, the point you have to deliberate. So in the force of a commercial dispute, consider to answer the following question. 4, what you will see in printout. What are alternatives to transnational litigation? So actually, contact and negotiation would be more powerful, most powerful way to resolve the commercial dispute. You see? So, if impossible to resolve the case on that basis, then the parties may advance to contemplate whether to proceed on dispute resolution mechanism. Where will a future dispute be argued or settled? And what country's law would be applied to such a dispute? Will a settlement or decision be enforceable in a foreign country? These questions actually imposing and should be discussed during the earlier stages of a contract negotiation. And an international contract should, in earlier stages of contract negotiation, need to express and answer these questions through the use of forum selection, choice of law, and alternative dispute resolution clause, which we usually group into terms a boilerplate clause. These types of clauses often inserted, notwithstanding the types of contract. It may have a place in a construction contract, for example, and may be agreed upon in a sales contract or agency contract or others. It is common and one of typology in dealing with a commercial dispute resolution. So, the answer to question 4 is that international commercial arbitration is a popular alternative to international litigation. The contractual devices represented by choice of law and forum selection clauses provide the avenue for dealing with questions. Second and third. As you see, the choice of law clause is important and often may be present across types of international contract, as you see. And the court often respects the agreement reached by both parties about choice of law. However, all the jurisdictions have a conflict of laws, which is domestic in nature, quality. And as you see, we have very straightforward and enlightening rules when the restatement of clause have provided, as you see later. In some cases, public policy of a specific jurisdiction may intervene. For example, what is fair terms of statute in United Kingdom. So unconscionable clauses may now be often arise as a feature of travel in the international contract. So the disparity between the bargaining power and economic status in countries may drive the parties to have no way but to agree upon the closing terms, which is unconscionable. And they may more vile to impose some of a choice of law agreement in the contract to avoid that some of a mandatory penalty about kind of a unconscionability. So they may agree on other forum which is more generous about the protection of consumers or others. In that case, the British statute, they recognize kind of agreement, which means in that case the freedom contract or economic autonomy of parties would be effectively vacated. And also one other incident now penalized by a British authority would be the indemnification clause. For example, the consumer will be mandated to indemnify kind of losses or damage in the course of a contract performance. However, in that case, we see no reason to bind the consumer to indemnify, and often be considered unconscionable and as posing challenges for the economic justice. So in that case also, the relevant statute invalidated kind of a arrangement, which nonetheless be based on mutual agreement of parties. Meeting of minds of both parties are meaningless in that case, since we see some of injustice, which is irresistible for the case in the parties. And also, forum selection clause to be seriously studied to protect the businesses' interest. Actually, how to design the contract and what terms and conditions may be negotiated and to be reduced into writing is in primacy and very essential to preserve the commercial, the trade interest pursued by both parties. So we now know the two types of dispute resolution could be exploited for business people. One, international litigation and a commercial arbitration. And in terms of international litigation, we see two strengths important: service of process, and as you see later in evidentiary problems. discovery procedures. So we have two international conventions to respond with kind of issues. Service, Hague Service Convention. What is the official title of that convention? Because the Convention on the Service Abroad of Judicial and Extrajudicial Documents, Civil or Commercial Matters. And as you see in discovery issue, the Hague Evidence Convention. And that is the product achieved through the series of international effort and a scholarly discussion, kind of. So it actually consumes many years to reach. Often the case in scope of a international convention, CISG, what are those? And also, you see in some aspect, the national contention is serious. For example, you may now get the discovery process in civil litigation. The United States has a very liberalized paradigm of a discovery process. You see federal rules of civil procedure and others, and what is innovated with a vast extent of a means and instrumentalities, notably what is the pre-trial discovery process. So the kind of a new initiative actually has high chances to contradict the kind of traditional notion of national sovereignty. It actually very jumble of areas that national sovereignty and international cooperation may compete each other. Actually, liberal procedure to the evidence and get the evidence and present the evidence in the court proceeding, specific national context, actually is a virtue in many aspects. Often it ensures the civil justice is more prudent and also essential to disclose case in genuine and pertinent facts, which suppose the justice. However, some countries, and, which is fairly extended and often criticize kind of compulsory measure, which is critical as one of extraterritorial application of national law. So, resilient, in some cases, resist to produce the evidence, and often involved in kind of a compulsory measure, subpoena, what is a compulsory order to produce the written materials, documents, which is in the possession of parties located in other countries, foreign countries. It's actually in conflict about authority and compulsion. So it is actually squeezing and in many aspects aroused kind of a conflict, as you see. And so I consider both convention is very fruitful from competing voices in the international community. Of course, not all the countries subscribe to these conventions. For example, 55 states have adopted the Hague Service Convention, including the United States, Japan, China, France, Germany, Great Britain, Italy, Spain, and Canada. In countries not party to the convention, dual service process is recommended. Dual service aims to satisfy the service requirements of the country of foreign court and the country of the defendant in order to enhance the enforceability of any future judgment. So actually this convention compresses a cumbersome process, often we call a dual service of process, which is required to enforce the judgment. You see, the national authority often is disposed to preserve the national sovereignty and also protect the citizens and others. So the service of process is very important if the defendant of the national identity would properly serve and ensure the fair opportunity to defend the case. So the service of process is actually difficult, particularly in international context, and in many cases the default judgment is actually popular. So in this case, default judgment would not deserve any kind of due status in terms of enforceability of judgment. So the national authority often requires to meet the service of process, which set forth in the Civil Procedure Act. So in your class of civil procedure, this law department, you are introduced perhaps about the rules and provisions in the first of a class. And also that dealing will be duplicated in last part of a term about what is a proper foreign judgment to be enforceable. Service process is duly served to the defendant waters, and from the traditional Roman rule and laws, the protection of defendant in the civil litigation is ultimate factor to secure justice between the parties. Often. So that is a dilemma that business people and international commerce witness of decades. How to centralize the kind of a service of process in one scheme or ambit. And Hague Service Convention explains for some of them and may have response. It provides a central authority for processing a foreign plaintiff service of process request. We also a member state of this Hague Service Convention and designated the administrative unit of a Supreme Court of South Korea as a central authority, and they are centrally responsible to deal with service process in international context. The only a avenue and authority to respond with, which means its normal validity and effect in more a stronger commitment. So diverse agencies often travels a clear and straightforward dealings of the case and may vitiate the effect, legal effect. However, a decentralized central authority, the institution of central authority in this convention would resolve that dilemma very ambitiously. Of course, the central authority may exploit kind of a national agencies, diplomatic channels, and others to cooperate in delivering the service process to the parties residing in foreign countries and others. And also, you see, the international discovery, concerns and others, what is official title of convention, Convention on the Taking of Evidence Abroad in Civil and Commercial Matters, what is popularly called a Hague Evidence Law. This convention is to facilitate the discovery of foreign parties, as said, and it provides for the use of letters of request that require foreign courts to perform the discovery process. It also provides for the taking of evidence by diplomatic officers, consular agents, and commissioners. A number of factors limit the effectiveness of the convention. First, although the United States has ratified the convention, only 31 other states, very few of which are located outside Western Europe, have adopted the convention. So the scope of member state is actually limited and diminish its influence, and consider many forms of enterprise are now expand their business in other regions, countries, other than Western Europe. Second, the foreign court may reject the letter of request or if the court deems it to be in violation of its national laws. Nonetheless, the U.S. plaintiff having problems with foreign discovery should seek the help of the United States State Department in gathering evidence through the Hague Evidence Convention. And also, in terms of international litigation, the primary concern revolves around the enforcement ability of judgments. Traditionally, a rule of reciprocity has operated, which also now embedded in a Korean civil procedure. What is rule of reciprocity? The national authority often negates the enforcement of foreign judgment if the counterpart would have published not to endorse the judgment of Korea, for example. So the kind of concept which also prevailed over best scope of issues in the international law. So the rule of reciprocity is traditional. However, that is not absolute over the context of a national authority. For example, you see the trend now evolved over in U.S. and other, Canada, others. So now the U.S. Judiciary are well exposed to diverse culture, and now legal pluralism is often be substantiated with a adequate and detailed, a more enriched understanding of diverse legal codes or cases. So now the U.S. Code says it could be possible to assess the nature and quality of laws, and those aspects would be more in prompts to decide whether the foreign judgment may be enforceable in the United States or not. A rule of reciprocity is just a balanced concept which could lead, in some cases, a perfunctory outcome of about the issue of enforceability of judgment. So the U.S. Court consider himself to possess the competence to make it distinctive about is a Bavarian law that disqualifies for enforcement of in the United States jurisdiction or others. So, so plenary and authoritative could be possible in this intense interplay of international economy, as I said. So now the U.S. recognition of other legal systems are theoretically not based on a rule of reciprocity. In some cases, they recognize judgment and entitle it to be enforceable in the United States. In other cases, while the counterpart may endorse the U.S. judgment, however, negate its validity or enforceability of the judgments in the United States. So the context was later reviewed in cases, for example, Nelson Bunker and a BP Exploitation Company Ltd. This case involves English judgment, see, and we can have chance to take a typical operation of this rule in this area. What is that? So, as I said, you see, sorry. Emanates from my smartphone. I bought that smartphone yesterday. Used for. Actually, I'm not experienced about handling this device. Sorry to disrupt. So in this case, you see the traditional points often raised in the context of enforceability review, and their steps can well apply to the Korean authority also. What is public policy? Is the judgment in conflict with the national public policy, where the judgment sought to enforce. In this case, the court see it negative. However, the determinant factor in this case is about the nature of judgment that is sought to enforce. See, it the now appealed and pending in the highest court of the United Kingdom. So often the national authority are reluctant to enforce the judgment which is pending. The quality and nature of judgment is required of its finality. So irrevocable in which does not depend on any further subsequent development of the case. And also the Rule of reciprocity was rejected in the case titled Hilton and Gaia. The Supreme Court held the foreign judgment is entitled to enforcement if defendant had an opportunity for a fair trial. The fair trial is predicated on the foreign court possessing personal and subject matter jurisdiction, conducting trials using regular procedures, and acting on the system of jurisprudence likely to secure an impartial administrative justice. The other concept now be conceived as kind of an international comity. So the National Court of the United States often see it to be derived from traditional ways of international interplay. So due respect to the legislature, judiciary, and executive of foreign countries would often be practiced in long-term basis, which is inviolable and embedded into international, the notion of international law. So that is the point that the United States respect. However, the exact scope is not certain, as said, and it is also notable. You see, the United States Court have developed an extended scope of a international question and legal response. For example, what is a political question doctrine, and what is a state action theory, act of state doctrine. And also in that context, your concern needs to be shared on some of important statutes. Okay? FUSIA, what is FUSIA? Federal Sovereign Immunity Act. And this concept will also be pursued in earlier stage in Great Britain. So the United Kingdom also has the kind of statute. And you see, the case Kuwait Airways Corporation versus Iraq Airways Corporation. This case is interesting and very distinctive to understand the preaching of this role. You see, in the Iraq was condemned as a aggressing state against Kuwait. Kuwait was conquered by the arms and weapons of Iraq and actually got into disillusion temporarily about its state operation. In the development event, the Iraqi forces exercised dominant domain, seizure Kuwait Airways. And what is a traditional function of state? That would not cease and develop into some of economic merge. You see, and Iraqi military and the removal from the country at the direction of the Iraqi government during the invasion of Kuwait in August 1991 was sovereign, actually, in the course of a military operation conquers. It's a traditional scope of a sovereign, you see, military affairs. What other? Command and dictate is often the stigma we see in classification of a state function. So there's a case. However, subsequent government orders dissolving Kuwait Airways and transferring its assets to Iraq Airways violated international law and were not exercises of sovereign immunity subject to state immunity. So the case was litigated in the British House of Lords. And also the House of Laws made it distinct between two steps of actions. The first step is state function. However, the last case may not deserve the kind of a due status as a state function, not quality, no quality to be ascribed to traditional preserve of State Act. So it may subject to British House of Lords jurisdiction. And the Paradox Bank versus Russian Savings Bank case further elaborates upon the commercial activity exception to foreign sovereign immunity. So king can do no wrong. That is a basic concept embedded in state sovereign doctrine, sovereign immunity doctrine. However, that is not the case. Consider if the government is engaged in procurement of the services of goods and necessary to support the governmental function. That is often frequented in the contemporary context of government and economy. And consider if a joint venture agreement about investment may be reached by international enterprises, businesses, and a specific government. So often it is a pattern to respond with a joint venture investment. How to deal would often be preempted by that kind of arrangement. It is most advantageous if the host country is a partner of joint venture. They have plenary power to make laws. So international business may be honored and prefer to make them as a partner. And also now, have you come across the word city politics? Now the international businesses frontier some of a concept about interplay between the local government and enterprise. You may have some local news stories which frequented the TV news rather. Gwangju successfully entered into an investment agreement with the foreign investors rather. It's a kind of partner. So now the central and local governments in some sense, the main players to respond with the international economy. They are one partner. So the scope of commercial activity actually enlarged in a stark fashion. So one point to understand this area of law, state immunity. So the FUSIA, Foreign Sovereign Immunity Act of the United States defines the commercial activity as a regular course of a commercial conduct or particular commercial transaction. Then what is the exact meaning of this provision? The U.S. Supreme Court has elaborated on this term by noting the foreign government acts not as a regulator of a market, but in the manner of private player within it. The foreign sovereign's actions are commercial within the meaning of FUSIA. The activity must be within the power of private citizens rather than those reserved exclusively for sovereigns. The problem with this type of categorization of activities is that government procurement has become increasingly commercialized, making the distinction between sovereign and commercial activities difficult to define. So it is actually a very great problem the court may encounter in international litigation. In exercising their jurisdiction, it comes as a first issue to be resolved. You see, once Korean Asset Corporation was accused in the U.S. court about its dealings. So actually, they prefer in contrary commitment with the market principle, favor the worst condition of a corporation. So it is kind of a evil for the foreign investment who is the United States citizen. They are required to act in compliance with market, which is a reasonable way to yield the interest to others. Beyond the rule, we may see some of very important factors will often be debated in the court. You see, the practical factors in the spectrum of a considerations, for example, would work to determine whether the Korean Asset Corporation is governmental entity or not. So, how the corporation make their business decision? Are they constituted of a governmental officials or other directors? Are they paid by government? So many factors to be considered to address the status of a Korean Asset Corporation. And as you see, Korea and many other countries, of course, have some of a scope of public enterprise. Korean Asset Corporation is one of that kind of entities. And also we have Korean Gas Corporation. KT, what is KT? Korean Telecommunication, Power Company. Often, traditionally, they operate under royal charter. You see, in the history of the United States. And they often exercise monopoly or dominance of the sector of the business, which enables them a tremendous amount of profits. We consider the United States comes in less context, in less aspect of those utilizing kind of public corporations. However, Korea, France, I'm not exposed to Japan or China. However, a socialist tradition kind of involves to see that ways of commercial dealings. So you see the newspaper story, the party is over. What does that mean? Who is principally responsible to address national economy, commented, the party is over. So now the public corporation, business entities are turned to be a subject to critical eyes of a government also. They are actually now critiquing the inefficiency and failure to manage properly. So the standard would now be cast in leverage with the private market dominance, dynamism. Actually, now the economy is interwoven intensely and may be structured in some of complicated ways and inviolable structure, which is very stiff and hardly resolved in this stage of time. So state is also primary to involve in the economy. They are principal supporter to boost national economy. The traditional concept between private and public sector now be highly tainted and tarnished, and now considered to be inextricable, recoverable to return to the kind of a basic notion, to actually intersecting, interwoven, subject to some of a fatal destiny, you see. So that is also related with our point between traditional notion of a sovereign activity. So it is actually difficult to define clearly between the sovereign activity and a commercial activity and non-commercial activity. The activity must it is important in such dealings to negotiate contract clause in which the governmental entity waive the sovereign immunity defense. So the private parties would be wise to prepare clause about waiver of sovereign immunity rights. Particularly, must be referenced in advance when they enter a joint venture agreement. So it is one of erroneous dealings in view of a Korean asset corporation case, you see. So the foreign investor may have more chances to seek the proper justice on the equity. Actually, the case was dismissed in advance based on this statute, FCI. Korean Asset Corporation was deemed one of a governmental instrumentality. So treat is the same as a government. So it is rendered to entertain sovereign immunity in purview of a FUSA statute. And furthermore, judicial determination of the exercise of sovereign power or commercial activity may not characterize an entire transaction. And the two coexist in a set of a interrelated transaction, as you see in Quaid Airways Corporation case. And I have introduced the Act of State doctrine, which is one of a case law series dealing with this kind of question. It has been ascribed as non-jurisdictional prudential doctrine based on the notion that the courts of one country will not sit in judgment on the acts of government of another, down within its own territory. In Sabatino, the United States Supreme Court delineated a three-part test to sit courts in determining whether the Act of State doctrine bars consideration of specific claims. The test consists of balancing the degree of codification, consensus concerning the particularity of international law at issue, the implications of judicial resolution of the issue, the U.S. foreign relations, and whether the government whose actions are at issue remains in existence at the time of court decision. So it actually respected that the State Act would not be submissive to the exercise of foreign jurisdiction. That concept also is incorporated in the United States. Of course, it is a federal statute and one nation about a diplomatic concept, a diplomatic structures. However, the state government is not amenable to the jurisdiction of other states. This is a federal code. Sovereign immunity was reserved in the matter of law. And also the federal government is one of sovereign in the United States context and may not be ruled by other state courts. The concept is the same in sharing and also basic intelligence in this way of thinking, you see. So the State Act may not given a particular justice by a foreign court. And also some controversy about this rule would be concerned about the scope of effect that this rule mandates. So, for example, how the reasoning of court opinion may be subject to the foreign state jurisdiction would be questionable. The outcome of case may not be manipulated in other jurisdictions. However, it is dubious if the foreign court may also respect the kind of details of court opinion or reasoning. So actually it involves a diverse ways to be applied in a case-by-case basis. And also, we have another doctrine relevant with our discussion scope. The political question doctrine. It provides a political question is not subject to review by courts. The doctrine precludes a court from hearing a case involving one or more of the following factors. So it is a very aesthetic rule, which is also eminent in influence and may impact profoundly over the code of a constitutional state. So how we qualify the scope of cases which is related with this doctrine, a constitutional commitment of the issue to a coordinate political department. Actually, the Constitution is expected to operate on the separation of powers principle, so it distinct preserve to be inviolable. Of course, may be subject to check-up and balance rule for balance of powers and effective protection of a liberty interest. One kind of very shrewd device, the constitutional drafters have ambited and envisioned to protect the interest, commercial interest. So one concept lays the United States Constitution actually on plutocracy, the rising commercial class is the main actor to draft the Constitution. The separation of powers principle is actually a very powerful device to ensure the commercial interest. So one unitary governance would jeopardize the commercial interest. Executive, legislative, judicial may not cross to impose the commercial interest. actually, when you consider royal charter, what it is, earlier capitalist, it is fairly imposing and often limited the opportunity to economy of business. So the royal power now be separated into three parts of quality in political power. So the liberty or property right is actually deemed inviolable and in sanctity. So the political question has several elements to be satisfied. So actually the case of controversy is entitled the judiciary the power to resolve the dispute and controversy. So it is one way to look into justiciability, whether the dispute may be properly termed as a case of controversy. Even the strict legal requirement may be met, the political question doctrine may disrupt, intervene. The judiciary may not advance to dispose a specific determination. So what entitles the kind of operation of this doctrine? Lack of judicially discoverable and manageable standards for resolving. So it is very cumbersome that the judiciary may say this or not. Most notorious case in this area would be Becker versus Cox. So gerrymandering may brought into court litigation in that case. How do you consider the congressional authority about making the election law? Is it fair or abridges the fair the equal protection of law in voting or others? Equal right to vote. It may prejudice the kind of political participation of the citizens in equal terms and qualification. So reasonable, permissible scope of gerrymandering. But gerrymandering actually problematic. However, permissible scope of sections or electoral districts could be delineated. In that case, actually, the court advanced to reach a substantial resolution of the case. That is also be shared similarly in Korean Constitutional Code, as you see. So actually, administration often make the agenda very challenging and also now we discussed the growth of a Chungnam population. That issue also one concern in contemporary Korean polity. However, Jeonnam province nowadays, how do you consider? So the judicial justice may intervene in some is actually political issue. It's very challenging and actually intriguing intrigued in terms of a proper election administration, and often involves the individual liberty and equal protection of laws. I suppose you may learn a scope of rules and core rationales about gerrymandering and election laws in your constitutional case. And the impossibility of deciding without initial polished determination of kind clearly for non-judicial discretion. So the quality of issue may be reserved exclusively by the constitutional drafts for the political branches, legislative or executive. The impossibility of one's of course undertaking independent resolution without expressing a lack of respect due coordinate branches of government. An unusual need for unquestioning adherence to political decisions already made, or the potentiality of embarrassment from multifarious pronouncements by various departments on one question. So actually, the court may often find it indispensable and necessary to share a same voice between among the three parties. It may not be disturbed by any branch rules, judicial rules or series may be impertinent in some cases, work to make the nation into turbulence, kind of. So uniform response and also one voice would be pivotally required in some preserve or in the nature of cases. Then political question doctrine may well operate to ensure a more adequate constitutional rule, as I said. How do you consider? So the courts, in applying this doctrine, actually investigates the scope of factors. As I said, what is there any rules defined clearly to this question? There's concept. And in some cases, it may involve foreign affairs, which should be exclusively reserved in actually, of course, it is not a matter. However, in some cases, you see in now the damage issue of a comfort woman in grand jurisdiction. How do you consider the case was disposed favorably for the comfort woman in the Gwangju local district court? Actually, the foreign policy is typically represented by the president, you see, and the Constitution may have several provisions pertinent to the foreign policy making. What is war making authority? You see, expected to be exercised in consonance with the president legislative. And also, it would be nationally strategic and in legal terms reserved with the president. That the president may have more eminent status to exercise foreign policies. So the judiciary would be secondary in that aspect, for example. However, I consider it not improper if one local code may advance to dissolve the case specifically and restore the civil justice against the aggrieved parties, the comfort woman. And also, how do you consider the probabilities of enforceability of the judgment in the U.S. Japanese territory? And also, when we think about international litigation, we have two important rules. What are those? The forum non-convenience doctrine and also the doctrine of venue. For example, we may consider venue, which is a proper venue, even if we find some of a varied and competent jurisdiction to dispose the case. So Seoul Central Court would be a proper venue or others. In this context, you see some of important statute dealing with question, the alien venue statute, which was promulgated by the United States, and it is concern of federal litigation. So with respect to federal litigation, the alien venue statute provides the aliens may be sued in any federal judicial district. So no statutory requirement was set forth to assign the case into any specific jurisdiction. So comprehensively, the federal district court may be invoked as a proper jurisdiction for the aliens in terms of venue. But one exception, the foreign government would only be submissive to the U.S. District Court for the District of Columbia, located in Washington, D.C. And also the forum non-convenience doctrine is important that the international jurists may well rely on. So actually the jurors often face some of difficulty, practical difficulty for the production of evidence or subpoena witnesses. How can they make a varied service process to initiate their civil actions? And often the court proceeding may more well be afforded in terms of a discovery and evidence interrogation kind of and the probability on enforceability of a judgment, and the many factors to be considered and weighed in to make other alternative jurisdiction more effective and proper forum. In that case, the forum non-convenience doctrine may allow the jurisdiction to be transferred. Of course, in that case, the United States rule requires the forum court must provide an alternative forum to be transferred. In application of this doctrine, courts engage in two-step process in deciding whether to dismiss a claim based on forum non-convenience. The first step is determining if an adequate alternative forum exists. If such a forum exists, then the court must balance series of factors involving the private interest of parties and the public interest in maintaining the litigation in the selected forum. Public interest factors include court congestion, the unfairness of imposing jury duty on a community with no relation to the litigation, the interest of community in having localized controversies decided at home, and avoidance of problems associated with conflict of laws and the application of foreign law. What are private interest factors? They include ease of access to evidence, the cost for witness to attend trial, the availability of compulsory process, and other factors that might shorten the trial or make it less expensive. The plaintiff's choice of forum is subject to judicial difference, and the burden of demonstrating the existence of an adequate alternative forum and the balance of private and public interest favor trial in the foreign forum rest with the defendant. So we later consider the case titled Capital Currency Exchange Rate. It examines some of nuances of judgment doctrine. So in that case, certain remedies are available because of a differences in legal traditions. So we have three major legal traditions, as you see: civil law tradition, a common law tradition. For example, the punitive damages may not have been endorsed in a civil law system with a kind of a closed concept, a deposit in francs may be identified. However, often some remedies may be waived and arose in different fashion. So, and it is actually determinative in perspective of dispute parties. The remedy is critical. Final destination they pursue in court proceeding. So the availability of certain remedies are important. However, in the court viewpoint, that factor does not render that forum inadequate. And in that case, the court ruled to conform the basics of a forum non-convenience. In that analysis, the court must determine that an adequate alternative forum exists. An alternative forum is adequate if the defendants are subject to service of process there, and the forum permits litigation of subject matter of the dispute. And the court actually reached the conclusion that there is an adequate alternative forum. So, any question? You could identify kind of a helpful highlights and tips produced in the box form, as you see. I extensively foregone this call. So that will be for the next class. So we will review the rules and some of practical tips helpful for business people. Then I expect all you fill in the name, catch up, no problem. And you, the last person. So usually for your reference. Okay, thank you for your attention. See you in the next class.